Sometimes you see a court ruling and think, okay, that's that, denied. But every now and then you find one where the real story is buried a little deeper. And this ruling, well, it has a major twist that you really don't see coming.
Right? You read the first part and it all seems pretty straightforward. A request is made and a request is denied. You'd think you've got the whole picture. Case closed. But this ruling is just a perfect example of why you've got to read all the way to the end. Because what looks like a shut door is, well, it's something else entirely. So, what is really going on here?
Okay, so the whole thing kicks off with two key applications from the claimants. And at first, the response from the court seems to be just a straight-up pattern of refusal.
The first thing the claimants wanted to clarify was whether they could publicly talk about or use materials from a settlement conference that happened back on July 21st, 2025. The court's answer on this was, well, it was crystal clear. Absolutely no ambiguity, the door was slammed shut. The transcript, any part of it, stays confidential. No quoting, no paraphrasing, nothing. So that's denial number one. But that wasn't all. They also put in an application for the respondent to cover the costs of an interpreter for 6 extra court appearances that they argued were, caused by the respondent in the first place. And again, the court's ruling was just as blunt. Application to a judge is dismissed. Simple as that. So let's recap. That's 2 requests from the claimants and 2 very firm no's from the court. And honestly, if you stopped reading right there, the story would be pretty simple. Denied again. It really looks like a total setback for the claimants. Because it turns out those weren't the only denials the court handed out that day. And this, right here, is where the entire story just completely pivots.
Now, this is what's so fascinating. The court keeps that pattern of denial going, but all of a sudden, the target changes.
The whole dynamic just gets flipped on its head, because the court then turned its attention to the respondent's argument that the settlement from July 21st was final and binding, and it rejected it. And that's right there. That is the absolute turning point of this whole thing. The court essentially invalidated that alleged settlement. So while the claimants lost on those 2 procedural points, they won on the core issue that really mattered. This one decision completely changes the game. The fight over whether there was a locked-in settlement is officially over. And now, a whole new phase of this case is about to begin. So what does set aside actually mean here? Well, to put it simply, it's like the court just hit the reset button. That supposed agreement from July 21st, it's off the table. It's no longer considered valid, which clears the runway for this case to finally be heard on its actual merits. And that next step is a pretty big one. We're now looking at a 4-day trial. Unless, of course, the parties can manage to reach a totally new, and this time, lawful settlement. So all that back and forth about documents and signatures, that's done. The focus is shifting away from that and onto the facts, the evidence, and the actual claims at the heart of the case. It's a huge change in direction. So, great. The path to a trial is finally clear. But this win, as big as it is, doesn't just magically erase some of the very real practical challenges that have been there from the start. And it's really important to understand the landscape here. I mean, there's a significant imbalance at play. On one side, you have the claimants, 2 former providers who are representing themselves, and on the other side, you've got the respondent, backed by a team of professional lawyers and all the resources that come with that. And that imbalance creates some pretty serious hurdles. For one, the need for a certified interpreter is still a live issue, and you can imagine how the costs for that can just skyrocket during a full multi-day trial. Plus, the claimants are still facing the massive task of developing trial strategy and handling cross-examinations without any legal counsel of their own. But look, despite all those challenges, this is the real takeaway here. The procedural logjam has been broken. The case isn't stuck anymore. The path to a real hearing based on facts and evidence, is now finally, officially open. And that really leads us to the biggest question moving forward, doesn't it? After all this time, after all the procedural battles, what actually happens when the substance of this case, the facts and the evidence, finally get their day in court? That is what everyone will be watching for next.